In the individual mandate case, the federal government's flagship case is Wickard versus Filburn. You've heard me talk about this 1942 case before. I wrote about it in Men in Black. I wrote about it in Liberty and Tyranny, and I touched on it again in Ameritopia. That's how important it is. And yet it has absolutely nothing in common with Obamacare's individual mandate. You know, I was reading these briefs when we were completing our first brief. And people were, let's do this and let's address that. I said, wait a minute, they're not parallel. In fact, it underscores, as we write in our brief, Obamacare's unconstitutionality. You see, in the Wickard versus Filburn case in 1942, the government did not mandate a farmer to grow wheat. It sought to regulate the wheat the farmer, by his own free will, chose to grow. Moreover, the government didn't compel the consumer to purchase wheat. Whereas in the instant case, it compels the consumer to purchase insurance. There would seem to be few limits on federal power where individuals are ordered to produce things and individuals are ordered to purchase things. To assert a constitutional basis to justify such an unprecedented seizure of authority by the federal government is simply nonsense. Once unleashed, what are the limits to this new unconstitutional assertion of power? And the liberals never want to answer this, ever. Having so thoroughly contorted the Commerce Clause, what are the discernible limitations on congressional power? The court should be mindful that the past Congress and current administration seek nothing less than to fundamentally change the relationship between the citizen and the federal government. Perhaps this court, we're asking the court, perhaps this court will inquire of the federal government the contours of this new authority it claims, and hopefully it'll do that tomorrow. The federal government also invokes, but let me just say, some people talk about the Constitution. We're really digging in today, with both hands and shovel. We're getting into this thing like nobody else is going to, so stick with me. The federal government also invokes the Necessary and Proper Clause, we've talked about this, to defend what is indeed an unprecedented national police power. But the Necessary and Proper Clause does not create any additional congressional power, nor does it expand any enumerated power. The individual mandate is not a discrete and narrow exercise of authority over a small class of persons already subjected to federal power. The Necessary and Proper Clause does not justify the individual mandate, as Congress never had the authority in the first place to compel private parties to engage in private economic activity based solely on the fact of living. Oh, yes, we saw the articles last week. I mentioned them. Oh, the government has a new argument, Necessary and Proper Clause. It's not a new argument at all. We filed this brief in February. They just keep throwing it against the wall. In our brief, which is online at landmarklegal.org, we cite the Ogden versus Sanders Supreme Court case, 1827. George Will is out there writing about contract law, that he's reviewed all the briefs. He apparently didn't review our brief. And that case stands for the proposition, and I quote, listen to this. Individuals do not derive from government their right to contract, that is, to enter into a contract, but bring that right with them into society. That obligation is not conferred on contracts by positive law, that is, congressional law, but is intrinsic and conferred by the act of the parties. This results in the right which every man retains to acquire property, to dispose of that property according to his own judgment, and to pledge himself for a future act. These rights are not given by society. They're brought into society. This isn't Mark Levin philosophizing. This is in a Supreme Court decision in 1827. Ogden versus Sanders. Saunders, I should say. And the irony of the government's own position is lost on the government, which now asks this court to rewrite the Commerce Clause, to define the individual mandate as commerce, when in fact there's no commerce but for the government unconstitutionally compelling individuals to enter into private binding contracts against their will. Now, stick with me. This is a smart audience. You're smart people. Not the morning zoo. You know, I'm not doing the baseball, the March Madness scores. Just stick with me. Because any fool can do that stuff. So they cite this Wickard versus Filburn decision. And there's a more recent decision called Raich. R-A-I-C-H. Involving a lady who illegally grew marijuana. In Raich and Wickard, individuals actually produced or possessed a real product for which there was a national market, legal or illegal. In the Obamacare matter, the individual who is compelled to purchase private health insurance is neither creating a product nor providing a service. He's not doing anything. Therefore, the individual is withholding nothing from commerce because he's producing nothing. This is in the brief. In Wickard, as I pointed out, the farmer grew wheat, which he withheld from interstate commerce. The court rationalized in that case, and later reinforced in the Raich case, that withholding wheat from interstate commerce disrupted the federal price scheme and thus was subject to regulation. In the Raich case, introducing a legal supply of marijuana into the national market would inevitably affect market prices. Okay? But the current matter has nothing to do with Wickard or Raich, both cases which are relied on by the Obama administration. It is the insurance company that creates the product or service, much like the farmer who grows the wheat in his field or the criminal who grows marijuana in her basement. No one disputes that insurance companies are subject to reasonable regulation. But the individual who is the target of the federal government's mandate is not providing any service or producing any good. He is merely existing. In neither Wickard nor Raich did the federal government attempt to compel an individual to purchase or grow wheat or marijuana. I suspect you'll be hearing a lot of our position in the court, hopefully by some of the justices tomorrow. Now, the so-called necessary and proper clause. Mr. Producer, you enjoying this? You learning from this? How about you, Mr. Call Screener? Everything okay? All right. Ladies and gentlemen, this is your future. This is the Constitution. This is where we are. I don't need to cite anybody else. We're doing this together. And this format is uniquely available for it. Talk radio. The necessary and proper clause. Early on, like back in 1819, McCullough versus Maryland decision, the Supreme Court made clear that the necessary and proper clause does not expand congressional power. The first inquiry must be whether a legislative end is constitutional and legitimate, whether it flows from an enumerated power under the Constitution. Next, the means must be appropriate and plainly adapted to that enumerated end. And these means may not be otherwise prohibited and must be consistent with the letter and spirit of the Constitution. So the question for the court, we said in the brief, is not whether compelling an individual to purchase an insurance policy as required by Obamacare is necessary to the successful implementation of Obamacare. Rather, the question is whether it is appropriate and plainly adapted to an enumerated federal power under the federal Constitution. That is, the point isn't to use the necessary and proper clause to uphold Obamacare. If Obamacare is violating the Constitution, then it's not to be upheld under any circumstances. And we write extensively about this, more than I choose to get into here. Anyway, folks, American history is replete with government efforts to influence the free market through a laundry list of incentives and disincentives. Okay? But the government has to follow the rules. And the rules are set out in the United States Constitution. And the government is not free to violate it. The Constitution is set up, in many respects, to dictate to it, to control it. The truth is, this is a slam dunk case. The truth is, despite all the legal jargon, it's a fairly simple case. And what the Supreme Court should do is knock Obamacare out. And in so doing, tell Congress, you want to reform health care? Go at it. Have a ball. You've got a zillion ways to do it. A zillion. But do it in ways that uphold the Constitution and our precedent. But particularly the Constitution. And the truth is, they could have, even from a very left-wing perspective, but they chose not to. And it is my deep hope, it is my prayer, that the justices on this court won't destroy the Constitution for this political expedient. Congress isn't going anywhere. Congress will address it again. But the damage to the Constitution will be permanent. It'll be permanent.